We find ways to protect our right to keep and bear arms anywhere we can. This weekend, I uncovered a powerful argument in favor of our right to keep and bear arms that I think we can use in court. How did I uncover this argument? Believe it or not, from an advertisement for the National Football League. That's right. Let me connect the dots for you when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 terrorist attacks on Israel teach Americans about the right to bear arms. We must learn from the good and the bad of Jewish history, how they discouraged, for many reasons, private self-defense oriented gun ownership, how they unlearned that lesson in the 1940s, started their country, and then became complacent on government to protect them, all with bad outcomes on 10/7/2023. And we talk all about this and learn the lessons of the mistakes they made, the good and the bad and the ugly, so that we Americans can learn from those and make sure we never lose our right to keep and bear arms, and we never stop defending our Second Amendment. All right, so folks, very interesting connection of dots over the weekend. This is something I've been thinking about generally in the context of fighting those handful of jurisdictions that remain terrible on guns, that are trying to drag their feet when it comes to the issuance of mandatory shall issue permits to concealed carry weapons. That's right. We know that after the 2022 Supreme Court decision in NYSRPA versus Bruen, may issue permitting regimes where governments have the ability to decide who gets to carry permits or who gets to carry guns and who does not, based on discretion of government officials, is verboten, is forbidden, not allowed under the United States Constitution's Second Amendment. Unfortunately, even though those states, those 6 or 7 states that are terrible on guns, you know who they are: Massachusetts, New York, New Jersey, California, Hawaii, Maryland, usual suspects. Even though they were forced to go to a full-blown shall issue permitting regime with no discretion, we know what a lot of those jurisdictions have done, like in New York. They've dragged their feet and made it very difficult to get a concealed carry permit, and they've done this by dragging their feet and delaying the process. So even though they say, yeah, we're going to apply objective criteria, which arguably they don't, but that's the subject of a different video, they basically say, hey, here's the story. It's going to take many months before we can give you an interview, and then it's going to take many months for the background check, and so on and so on. So they drag their feet and delay and delay and delay the issuance of the concealed carry permit that they undeniably have to give you under a shall issue permitting regime, unless, of course, you're a prohibited person under federal law, 18 U.S.C. 922G. So, how does this connect up with what I uncovered over the weekend? Powerful new argument that I think we're going to be seeing, not just in some scholarship coming out by yours truly, but also, I suspect, in some court cases coming up. Those challenging the delays associated with the issuance of concealed carry permits. I was watching some of the NFL over the weekend, and I noticed they ran an advertisement, and you'll see where I'm going quickly when I tell you what it said. The advertisement that the National Football League ran was called NFL Votes. NFL Votes. It was a public service announcement designed to encourage people to go out and register to vote. Now, by the way, this advertisement campaign by the National Football League has already been covered by news outlets like Breitbart and by the Federalist. And they've talked about kind of what groups the NFL has been working with, and they don't appear to be very conservative or anything like that. They don't appear to be particularly bipartisan, but that's not the purpose of today's video. What is the purpose of today's video is that what do these advertisements say? Well, the advertisement that I saw about NFL votes basically explains that, quote, the average time to register to vote is literally 2 minutes. That's what the advertisement says, literally 2 minutes. And then 2 additional players come on, because these are NFL players in the advertisement. 2 other players come on and say 2 minutes. And then another player comes on and says 2 minutes. So 3 times in this approximately 30-second PSA ad, they talk about how it only takes 2 minutes to register to vote. So that got me thinking, what other data is there out there about how long it takes to register to vote in America? And how long, based on the data, does it take to vote once you have that right to vote? Well, it turns out that according to an article I found based on the MIT Election Data and Science Laboratory, in an article in 2023, I'll put a link to it down below, there was a bipartisan presidential commission on election administration. And this administration laid out and explained that no American, listen very carefully to this, no American should be required to wait more than 30 minutes to vote. No American should be required to wait more than 30 minutes to vote. So that got me thinking. If the NFL says that on average it takes about 2 minutes to register the vote, and the MIT Election Lab data reports that I'll put a link to down below are talking about how no one should be required to spend more than 30 minutes to actually vote, and that on average, according to their data, the average time or the average wait time to vote in the United States in 2016 was approximately 10 minutes. Hear what I just said? In 2016, the average time to vote was approximately 10 minutes. I think that number went up to about, a little bit higher in 2020 because of COVID-related restrictions. But let's set that issue aside. The point is, whether we're talking about 2 minutes to register to vote, or 10 or more minutes, or even 30 minutes to vote, these are a drop in the bucket compared to the months and months and months that some Americans in anti-gun jurisdictions have to wait to be able to get their carry permit to exercise their Second Amendment right to bear arms. Right? To bear means to carry in public in anticipation of a confrontation and use of self-defense. So I think that one of the arguments we should be making here, and the reason why this is all relevant to the Supreme Court precedent in Bruen, is what the Supreme Court said in footnote number 9 in Bruen. Let me read you the language just to remind you what it says. In footnote number 9 in NYSRPA versus Bruen, they talk about shall issue permitting regimes, and they specifically say that these regimes are okay to the extent they apply objective, narrowly constrained or narrowly articulated and objective criteria, which basically is saying, we get to run a background check analogous to what we do on the side of the road with a police car pull over, right? When they pull you over, they run your driver's license. It takes minutes for them to find out all this information about you. So the question is, if it takes just a few minutes for them to run your record in a police car on the side of the road if you're pulled over, checking your driver's license, and they get all this information about whether or not you're a felon, have you ever been convicted, are there outstanding warrants for your arrest, and so on, how on earth can it possibly take months and months and months to get a concealed carry permit? It only takes a few minutes to run a NICS check. Certainly no more than a few hours if you want to play that game. Whatever it is, it's a drop in the bucket compared to the amount of time it takes to get a concealed carry permit in some of these jurisdictions. So again, turning back to the NYSRPA versus Bruen and what the Supreme Court said about this in 2022, footnote number 9, here is what they wrote that's very important. Justice Thomas wrote in Bruen, quote, because any permitting scheme can be put toward abusive ends, we, the Supreme Court, do not rule out constitutional challenges. Do not rule out constitutional challenges to shall-issue regimes where, for example, listen carefully, lengthy wait times in processing licensing applications or exorbitant fees deny ordinary citizens their right to public carry. Hear what I just said? The U.S. Supreme Court in footnote number 9 in Bruen points out that lengthy wait times to process concealed carry permits can give rise to a Second Amendment as-applied challenge to a shall issue regime. Now, the question is, what constitutes a lengthy wait time? Well, to figure that out, often you have to have some sort of standard to say, well, this is appropriate, this is not. It seems to me, just thinking out loud here, if it only takes 2 minutes to register to vote, according to the National Football League's NFL Votes advertisements, based on something I'm sure, if it only takes 10 minutes to actually exercise your right to vote on average in the United States, and that anything that takes longer than 30 minutes is considered improper, according to a bipartisan, election commission. And we also know, just objectively speaking, the amount of time it takes to run a NICS check and the amount of time it takes to have your background checked out when you're pulled over on the side of the road and a patrol car runs your driver's license. It seems absurd to think that it would be anything other than unconstitutional to make somebody wait more than at most a few days, if that, maybe a week. Be very conservative and favorable to the anti-gunners before you can get your concealed carry permit. Anything beyond that seems to be unconstitutional. Now, if it was my world, the way it should work is as follows. It should be no different than getting an ID, a voter ID or a driver's license. You apply, and as soon as you apply, as soon as you show the basic prerequisites, you should get a temporary concealed carry card that allows you to start carrying right then and there. And then the government can take as much time as they want, years as far as I'm concerned, to run background checks and check you out and Google you. It doesn't matter to see if you're a criminal or prohibited person. Because during that entire time period, you're going to be allowed to conceal carry. And if for some reason down the road they find out a reason why you're not allowed to be one because you're a convicted felon or whatever, so be it. Have them come on back. But as soon as you apply and meet that basic requirement, you should be able to walk out of there with a temporary concealed carry permit. No different than when you walk out of a DMV office with a temporary license that allows you to drive your car while you're waiting for the fancy-dancy card with your fancy-dancy photo and so on to be mailed to you in many states. Maybe a week or two later, but who cares because you can drive during that interim period. Anyway, so just a few observations about how an advertisement for the National Football League votes, PSA, connected some dots for me. Something I'd already been thinking about. I'm actually working on an article about licensing right now, and that's why when I heard this advertisement refer to 2 minutes to register to vote, I says, you know what? I think we've got another arrow in our quiver to fight the anti-gunners in these anti-gun states that don't like to give out concealed carry permits, despite the fact Bruen says they must. All right, folks. Well, hope you learned something here today. Make sure you follow me on X. We now have 18,000 followers on X at 4 Boxes Diner. Make sure you, if you're going to San Diego for the Gun Rights Policy Conference, sponsored by the Second Amendment Foundation this weekend, feel free to stop by and say hello. And we will see you again here at the 4 Boxes Diner very soon, I hope.
Orders up. Table 2A.